In court, every word matters. Every objection, every ruling, every moment when a person stands and says, "My rights were violated." But what happens when those words aren't preserved? When justice is spoken, but not remembered? In the American legal system, appeals depend on something simple and yet powerful: the record. Not just what happened, but what can be proven to have happened. So we begin with a question. How does the cost of creating a transcript affect who can realistically exercise the right to appeal? Should courts treat access to a verbatim record as a public good rather than a private expense? What procedural safeguards exist to protect self-represented litigants when no official transcript is automatically created? How do digital recording systems compare to live court reporters in terms of accuracy, reliability, and long-term preservation? What standards determine whether a record of sufficient completeness truly meets constitutional requirements, not just in theory, but in practice? How often do appeals fail simply because the trial record is incomplete or unusable? Do resource disparities between parties translate into unequal influence over how the court record is preserved? Should judges be required to issue written rulings when no verbatim transcript exists? How transparent are court policies about recording, retention, and public access to audio and video files? What role should legislatures play in funding or mandating court recording infrastructure? How do different states balance privacy concerns against the need for a publicly accessible court record? What ethical obligations do judges have to ensure a fair and reviewable record, even when staff or technology is limited? How does the lack of a reliable record affect public trust in the judicial system? Should appellate courts apply a different standard of review when the trial record is thin or reconstructed? What impact does this have on civil rights cases, where constitutional claims often depend on exact wording and context? How are marginalized and low-income communities disproportionately affected by record-keeping practices in courts? Could standardized national rules for court recording improve consistency and fairness across jurisdictions? What legal reforms would most effectively ensure that the right to be heard also includes the right to be accurately remembered? And finally, if justice depends on the record, who bears the burden of making sure the record exists? These aren't accusations. They are invitations to look at how systems work, to ask who they serve, and to imagine how they could serve everyone better. Justice isn't just about what's said in court. It's about what history is allowed to remember. So the question remains: who controls the record of justice?